Hello everyone, this side Nitu Singh, Assistant Professor of Indraprastha Law College. So in this subject, Indian Judicial System, we are going to start the writs. In our last lecture, we just go through with the some basic elements of writs in the Indian Constitution, and what are the provisions related writs in our Constitution. So in this lecture, we are going to start our first writ, that is habeas corpus. So let's start with the lecture. Okay, what is a writ exactly? A writ means a command of the court to another person or authority by which such person or authority has to act or abstain from acting in a certain way. So the writs are very essential part of the judicial power of the courts. If we are talking about India, yeah, definitely we are just talking about India. So in India, the constitution has provided the Supreme Court with the power to issue the writ under Article 32 of the constitution. Okay, and under Article 32, when any fundamental right of a citizen is violated, that person has the right to directly approach the Supreme Court for the enforcement of his rights, and the court can issue the appropriate writ for enforcing such right. ओके और सुप्रीम अगर हम हाई कोर्ट की बात करें तो अंडर आर्टिकल 226 में आपको द पावर टू इशू रिट्स आर ऑल्सो प्रोवाइडेड टू द हाई कोर्ट ऑफ इंडिया. Which article? 226. So there are two articles, 32 related with the Supreme Court and 226 related with the high courts. Okay, so in this situation, जब आर्टिकल 226 अप्लाई हो रहा है, while citizen can approach the Supreme Court only when his fundamental rights is infringed, and the citizen also have the right to approach the High Court for the issue of writs in other matters in which the fundamental rights are not violated. Okay, means 32 आर्टिकल में आप कभी जा रहे हो सुप्रीम कोर्ट के पास जब आपके फंडामेंटल राइट्स का वायलेशन हो रहा है, बट 226 के लिए दिस इज नॉट अ मैंडेटरी सिचुएशन. ओके, देन वी हैव द 5 काइंड ऑफ रिट्स. ओके, दैट इज habeas corpus, mandamus, certiorari, quo warranto and prohibition. So let's start with the first one, that is habeas corpus. Okay, the writ of habeas corpus is issued by the courts in those cases where a person is illegally detained. Habeas corpus means to have the body, and it is one of the most effective remedies available to a person detained. Habeas corpus is the most important one writ. Okay, basically these 5 writs names, these are Latin terms. You must know these all are Latin terms. Okay, habeas corpus is the important one because ये detained person के against में डिटेन पर्सन के केस में मोस्ट इफेक्टिव रेमेडी है. बाय दिस रिट द कोर्ट कमांड्स द पर्सन और अथॉरिटी हु हैज डिटेन्ड और रिस्ट्रेन्ड अनदर पर्सन टू प्रेजेंट सच पर्सन बिफोर द कोर्ट, एंड द कोर्ट रिक्वायर्स द डिटेलिंग पर्सन टू प्रोवाइड द ग्राउंड्स ऑन विच द पर्सन हैज बीन डिटेन्ड, एंड इफ ही फेल्स टू प्रोवाइड अ वैलिड ग्राउंड, द पर्सन हु हैज बीन डिटेन्ड विल बी रिलीज्ड बाय द कोर्ट इमीडिएटली. ओके, मीन्स की यहाँ पर क्या है, अगर कोई इंसान को कोई इंसान कैद में है, ऑब्वियसली किसी इलीगल वे में, मींस कि अगर जो अथॉरिटी है उससे रिलेटेड, उससे अगर कोर्ट क्वेश्चन पूछता है और वो ग्राउंड्स को प्रोवाइड कराने में फेल हो जाता है, तो उस पर्सन को इमीडिएटली रिलीज कर दिया जाएगा. दैट इज़ द habeas corpus. और इसके लिए कौन जा सकते हैं? या तो वो डिटेन हुआ पर्सन खुद, या उसकी फैमिली मेम्बर्स, या फिर उसके फ्रेंड्स. ओके, suppose that A is wrongfully detained by B, a police officer. A writes to the High Court regarding the same. The High Court summons B with A and asks the grounds for detained A. If B fails to provide a valid ground or justification for A's detention, A will be free to go. And the writ is very important for the personal liberty of the citizen, because if this writ is not provided by the Constitution, a person can be unlawfully restrained or detained by any authority. authority, and it will be clear violation of the person liberty of the citizen. And this writ can be applied not only by the person who is detained, but it can also be done by the some other person on behalf of the detained person, as I told you earlier. Okay, so there are some rules regarding the writ of this habeas corpus. The applicant should be in custody of another. Usually the detained person and his family members are allowed to file an application for habeas corpus, but the court has also allowed such application by strangers if it is done in public interest. Okay, आपको एक इसमें important case है रुदल शाह का. उस केस में मैं आपको भी orally बता दे रही हूँ. इसमें क्या था कि रुदल शाह को उसकी जो पनिशमेंट थी उसके अलावा वो 14 ईयर्स से जेल में था, उससे ज़्यादा टाइम पीरियड बीत चुका था. तो उसके बाद इसके लिए habeas corpus का रिट लिया गया और इमीडिएटली उसको फ्री किया गया. Okay, and a person cannot make the application for the writ successively to different judges of the same court. If an application is rejected by one judge, the same application cannot be made to another judge of the same court, and if it is done, such an application will be rejected because of the principle of res judicata, जैसा कि हमें पता ही है. And okay, so there are some rules related with this writ, that is habeas corpus. So what is the liberal approach of the court? In the case of the habeas corpus, the courts have recognized the existing socio-economic condition in the country and the fact that still many people are illiterate and poor. So the courts do not reject the application made by the petitioner on the ground that he has failed to show the proper ground on which he has challenged the detention. So this is also आप कह लीजिए इसको एक wider dimension है यहाँ पर दी गई है. So habeas corpus is the most important one writ because of कि यहाँ पे body से related चीज़ें हैं. मीन्स habeas corpus जो लैटिन टर्म है उसका मतलब ही है टू हैव द बॉडी, एंड इट इज़ वन ऑफ द मोस्ट इफेक्टिव रेमेडीज अवेलेबल टू अ पर्सन डिटेन. ठीक है, दिस इज द मोस्ट इम्पॉर्टेंट वन writ. So this is your first writ. That's it for this lecture. We'll continue with the mandamus in our next class. Thank you so much.